Good evening, gentlemen. I am sure our day was quite blissful and awesome. All right, so welcome to tonight's online session. I'm still your host, O.O. Stevens, and we are going to be looking at the topic membership of a company. We're going to be looking at the topic membership of a company in corporate law practice. We are looking at the topic membership of a company in corporate law practice. Now, membership of a company is defined to include, by virtue pursuant to section 79 sub 1 and 2 of CAMA, members of a company are defined to include: 1. The subscribers of the memorandum of the company who are deemed to have agreed to become members of the company and on its registration shall be entered as members in the register of members. Now, the first people that their names appeared in the memorandum of association of a company are known as members of the company. And remember that from the definition we just had now, these persons, their names must be entered in the register of members. So it is not just enough before you can actually be seen as a member of a company, your name must be entered in the register of what? Members. Now, the next category of people that are also members of a company are every other person who agrees in writing to become a member and whose name is entered in the register of such a member. So after those that have subscribed to the memorandum of association, there are still other people that can become the member of the company afterwards. And these are those that have agreed in writing, either definitely by buying shares of a company, then they will become a member. But it's not just enough. Before such a person can be seen as a member, he must have his name entered in the register of members. He must have his name entered in the register of members. Now, how can a person be a member of a company? How can a person be a member of a company? There are 4 ways through which a person can be a member of a company. 1 is by subscription. 2 is by allotment. 3 is by transfer. And 4 is by transmission. And 4 is by transmission. And we are going to briefly look at the concept of how to become a member by subscription, how to become a member by allotment of shares, how to become a member by transfer of shares, and how to become a member by transmission of shares. The subscribers of the memorandum of association who signed to their names as per being members of the company are the people that become members by subscription. If you remember in the subscription clause of a memorandum of association, you remember you drafted something like, we, the several persons whose names and descriptions have been subscribed to, are desirous of being formed into a company pursuant to this memorandum of association, and we variously take the number of shares from the capital of the company set opposite our respective names. So those people that make this collective statement are those that become the members of a company by subscription. So the people that their names appear in the subscription box of a memorandum of association are those who become members by subscription. And they must make sure that not less than 25% of the authorized share capital of the company is subscribed to at every material time. So not less than 25% of the company's shares is subscribed to. Now, what about those that become members by allotment? For instance, after a company has gotten incorporated, there are people that may come to the company to buy shares from the company. And those who are coming to the company to buy shares from the company are known as allottees. When the shares are finally given to them, they are known as allottees. So these are people that become members of the company after the company has gotten incorporated by buying shares from the company direct. So now, upon receiving the application of such an applicant, a company shall either wholly or partially accept the application, and they shall make an allotment to the person. Remember, I told you that Public company can invite members of the public to come and subscribe to their shares, but the private company cannot do that. So what we are discussing now is in an instance whereby somebody is giving the shares of the, but there are instances where the private company can give shares to the public, but that doesn't mean that it's the private company that invited the public. Such is called private placement. When we get to the topic on shares, we are going to treat that. Now, okay, if you listen to my voice note on the topic on shares, you're going to see that. Now, what we are now trying to look at now is when a person becomes a member of a company, after such a company has been incorporated, and the company gave such a person a particular number of shares, because you only become a member of a company when you have at least one share. When you have at least one share and your name is entered in the register of members, these two things must happen. You must have at least one share and your name will be entered in the register of members before you can become a member of a company. So what we are talking about now is that when the company gives you or allots shares to you, that means that you are a member by what? Allotment. Now, becoming a member by transfer of shares. The shares or other interests of a company are transferable in the manner provided by this article. But I want to briefly say something as a principle of law. A private company will, as a matter of compulsion, a private company must restrict the transferability of its shares in its memorandum of association. So a private company does not transfer shares. It is worthy of note. So a private company must restrict the transferability of its shares. Now, when we talk about transfer of shares, it is when, for instance, a member of a company, a person who is already a member of a company, maybe his wife was sick, or maybe anything happened to his family and he wants to sell the shares he has in a company to somebody else. That is what is called transfer of shares. And he wants to sell the shares he has in a company to somebody, that is called transfer of shares. Now, that person that buys those shares from him will, by virtue of getting the shares transferred to him, become a member of the company. Now, we now have being a member by transmission of shares. This is being a member by operation of the law. This is the devolution of shares in the personal representatives upon the death of a shareholder. For instance, a person that has a share in a company, if he dies, the shares he has in the company will now go to his personal representative. That is those that were his next of kin when he was alive. So the shares will now get back to the people, and those persons or that person will now, by virtue of that, having the share devolved to him, become a shareholder in such a company. Now, the person who owned the shares before his death can either be a joint shareholder or a sole shareholder. Sole is S-O-L-E. So a person who was a joint shareholder is when you own shares in a company with other people. That is not joint shareholdership. While sole shareholder is when it is only you that own the shares. So when you are a joint shareholder and you die, the shares will devolve to the surviving shareholders. The shares will devolve to the surviving shareholders. But if you are a sole shareholder and you die, the shares will now devolve to your personal, that is those that actually survive you. So maybe your family members, the shares will now devolve to them. That is the implication of what is obtained when you are a sole shareholder, or when you are a or when you are a joint shareholder. Also, there are some instances whereby a person who is declared bankrupt, his shares will now devolve to his trustees in bankruptcy. For instance, a person who is declared bankrupt is presumed in law that he does not own, he is not capable of anything. Declaring you bankrupt means that nobody should deal with this young man, or he is not seen in law as a person that is capable of doing business or entering into any agreement with somebody. So any property that such a person owns will now be managed in proxy. So if a person that is declared bankrupt used to have shares in company, then those shares are going to devolve to people known as his trustees in bankruptcy, which are to be appointed by the court. All right, let us look at the rights of a member. Let us look at the rights of, this is an exam area. Let's look at the rights of a member. Now, a member has a right to notice of meetings. A member has a right to dividend. A member has a right to a copy of financial statements. A member has a right to attend meetings by proxy. A member has a right to vote. A member has a right to demand poll. We are going to explain that demand poll and vote when we get to meetings of meeting. If you listen to my voice note on meetings of meeting, you're going to appreciate the concept of demand of poll. Also, a member has a right to requisition an extraordinary general meeting. Such, when you listen to my voice note on meetings, you're going to appreciate that. Also, a member has the right to take up minority protection action. For instance, in a situation whereby the right or the interest of such a member is not actually represented when the member falls under the minority. Minority are those that don't have much shares in company, or those that don't constitute the majority of those making decision in a company. Such a member has a right to take out what is called minority action. A minority action involves approaching the court for your interest to be represented and upheld. Now on that, we are going to be drawing the topic on this, we're going to be drawing the curtain on this topic, membership. And until we meet again, do take good care of yourselves and please and night rest.